Welcome everyone to this, the fourth event in our Legal Theory Symposium series this year. I'm very happy to welcome today our guest speaker, Kristen Rundle. Kristen is presently Senior Lecturer at UNSW, following 4 years as a lecturer at LSE. Prior to that, she held positions at the University of Toronto and the University of Sydney. Her areas of teaching include administrative law, legal theory, and law and the Holocaust. She is perhaps best known for her book, Forms Liberate, Reclaiming the Jurisprudence of Lon L. Fuller, which was awarded second prize, Society of Legal Scholars Peter Burke's Book Prize for Outstanding Legal Scholarship in 2012. And today, Kristen will be presenting her paper, Legal Subjects and Juridical Persons, Developing Bottom-Up Jurisprudence Through Fuller and Arendt.
Thank you, and it's also a relief to, as I was just explaining to Nicole, to be in jurisprudence mode for a couple of days, because I'm currently teaching administrative law in Australia and it's taken over my entire life. So if I lapse into comments about Australian executive power, forgive me, I haven't had a minute to think about anything else. So it's nice to move out of that frame. Although, as is always the case, I see the connections between what I am trying to convey to my students in admin law and what's going on in this paper. So, thank you again. Now, the background to this paper, as I have made clear in the actual setup of the text, is an invitation that I received from the Netherlands Society for Legal, the Dutch Association for Legal Philosophy, in conjunction with the Netherlands Journal for Legal Philosophy, to give an original paper at a symposium that they hold every 2 years in the Netherlands, where they concentrate on one particular person's work. Historically, their, we would say, editorial decision as to who they focus on has been what we would expect traditional approach, which is to invite someone and speak to the work of a very well-established scholar. So my predecessors in this include Gunther Teubner and Philip Pettit and others. The editorial team decided they were going to change tack. And no one will know that they've changed tack until another 2 years have passed, when we see that there's another youngish thinker that was being focused on. But in the meantime, I look like I'm among luminaries for reasons that aren't entirely clear, because they chose me as their first person to trial this experiment with. And what will happen is that upon presentation of an original paper, of which this was the initial draft, and it will be redrafted prior and then after that symposium, there will be 4 commentators in Amsterdam in June who will be responding to this paper, and it will all be published in the Netherlands Journal for Legal Philosophy later this year. So what that invitation presented and why it's relevant to what this paper proved to be, or I hope is going to become, is that it offered me a twofold opportunity to look at the project I undertook when I wrote Forms Liberate, which, as Sundram just explained, is this book here, from both before and after angles. And I say that because what the Dutch will call them specifically asked me for was something either related to my Fuller work or my work on law and the Holocaust, but it had to be new. So in the new part, it was an invitation to finally move out from the foundations that I had built in the Fuller book, or more of which I'll obviously speak to in a moment. But the upshot for introductory purposes is when I wrote that book, the project for me was principally a ground clearing one. And when you undertake a ground clearing project, you're often motivated by what you see you can do after the ground has been cleared. It was an enthusiasm for the kinds of questions I saw Fuller pointing to that I wanted to get to, but thought couldn't really be framed until we had readdressed his jurisprudence in terms that I thought was more appropriate to an understanding of it. That is what motivated that project. So the Netherlands invitation offered the chance to cross the threshold of where the book stood when it was finished and to move on to something new. But the before element is that because they were interested in my previous work on law and the Holocaust, there was a chance that opened up to revisit certain neglected intuitions that I had begun my doctoral project with, and that doctoral project is what eventually became the Forms Liberate book. And here it was all a bit unusual. I did not set out to do the legal philosophy work that I ended up doing in that book, or not as deliberately as it ended up turning out. It was actually an interest in Hannah Arendt, and it was an interest specifically in her comments in Eichmann in Jerusalem that really got me interested in these questions I saw her asking about what's the relationship between institutional design, or the particular form of different modes of social ordering, and the kinds of modes of agency or human behaviour that those sorts of forms generate. And then equally, there was this question of what do you do when we seek to judge human behaviour, and specifically Eichmann as the Nazi and the Nazi bureaucrat, through the modus operandi and presumptions of a form like a criminal trial that bore very little relationship to the environment in which he acted as an actor. So it was a range of questions about the disconnect, one might say, between law's response to Eichmann and the particular institutional environment in which he operated that got me asking questions about, well, how do we theorise about those disconnects? And if we don't theorise about them, if they're not part of our conversations about law and human agency, why are they not part of our conversations? And if we want to make them part of those conversations, what do we need to do in order to do so? Those are the questions that led me to a book on legal philosophy. Because the intuition I had then, and that I retained, was that Fuller had something to offer the answer to those questions that I was imposing about how to theorise these phenomena. And so over the intervening 10 years, this all happened in January of 2004 when I began my doctorate. I got on with the Fuller project, but I maintained an interest just quietly on the side in those original intuitions that there was something to be had between Fuller and Arendt of a conversation that could be illuminating for legal theory. And then since that time, there's been other elements of Arendt's writings, particularly those I emphasise here from Origins of Totalitarianism, that have caught my attention because I think she's on to something very similar to what I was focusing on with Fuller. So that's what this invitation from the Netherlands has enabled me to do, to go back to those original intuitions in light of everything that's passed since, and to ask myself, was there anything going on in them that's worth pursuing? So this paper is my first attempt to explore whether any of this was on track, and specifically to explore whether there is indeed a striking similarity on questions about what it means to be a legal subject between Fuller and Arendt, and I'm pretty convinced that there is a striking similarity there. But a less convincing position is what I hold, because I'm still exploring it, to the other question of whether an investigation of those similarities opens up something new. So I know that there's something going on that's similar. The question is whether exploring it is going to produce us new inquiries in legal theory or attach us to extant inquiries in legal theory in perhaps a novel way. So on those legal theory questions, I see myself as doing potentially three things in this project. First, I'm trying to offer something for how we understand the legal theory, if any, that infuses the writings of Hannah Arendt. And on that question, I offer my offerings quite tentatively, because she's not a necessarily well-organised thinker, and most importantly, she didn't set out to think about law for its own sake. So when it comes to ascertaining elements of her legal thinking, you have to do a lot of work with the leads that she gives. She doesn't necessarily follow up on those leads or seek to make them coherent with each other. But I do think there's actually a lot there, and I think it's clearly there in the sense that it doesn't have to be invented. I don't have to make great leaps to find it. I don't think so anyway, and I do think it's interesting. But it's tentative, what I'm offering there. On the Fuller side, this is my first attempt to take the Fuller that I reclaimed, for want of a better word, in the book, in the direction of a sympathetic conversation with a fellow thinker. Until now, the project I've been doing has been about dealing with Fuller's opponents and their enduring efforts to either distinguish their questions from his own, or to say they have his questions covered, which means we don't need him, or otherwise simply to keep him out of the picture. And so the question is, against that background of having to always work with the opposition, what might we find by working with sympathies? At the centre, however, of this paper is something that I think is deeply similar to what I undertook with Forms Liberate, and that is that I'm again trying to clear the decks to a certain degree to focus on questions and the extent to which our available theoretical resources, in substance and method alike, serve the illumination of certain questions. This might seem like an obvious thing for somebody to do, but it's what definitely motivated me 10 years ago when I began the doctorate, and that is a commitment to questions first and theory second. I find that a lot of legal philosophy is spent doing things the other way around, defending theories irrespective of what the questions are, or shutting off the question if it doesn't fit the theory. I'd rather work in the opposing direction, and generally also I'm someone who's very resistant to the labels, theoretical and otherwise, that we attach to projects until such time that at least we've worked out what the ideas are that the particular thinker is trying to give a run. So before we start talking, for example, about Fuller as a natural lawyer, can we look at what Fuller was trying to do and then work out whether that label actually assists us or not? So it's this commitment to questions over theories and hold the labels until the ideas have had a run that is what I'm aiming for here. And so instead of Fuller said or Arendt said, I'm interested in what they said and how it can be deployed towards questions such as the following. Can we theorise law, and is it constructive to do so, from the bottom up? And by that I mean, what does a theory of law look like, or might look like, that takes its foundational anchor from how a subject is positioned through law vis-a-vis the authority who has power over her? If we can pursue a bottom-up jurisprudence of this kind, which thinkers and what elements of their thought help us to do so? If these resources are or have been held back from our attention, why have they held back, and is that holding back justified? Obviously, a lot of my interest in looking at Fuller's work was in that question of what is it that made us misunderstand him, or what is it that caused his thinking to be held back? What is it about the frames of our conversations that do that holding back, and how can we defend that as the right way to undertake intellectual endeavour, particularly in legal philosophy, and how might we push back against it as perhaps a problematic way of doing so? Another question is, which of the enduring questions of legal theory itself bubble to the top and take priority if we start looking at things from the bottom up? And here I especially have in mind questions, and I only get there, I'm not happy with where the analysis of this paper goes in terms of how solidly it heads into these questions yet, but I'm particularly interested in questions about the conditions that make legal authority possible, and the question of how significantly ideas about the rule of law feature in our understanding of law itself. So my interest is in whether the bottom-up orientation has those kinds of questions come to the fore much more clearly than they might do if we were, for example, looking as we do through dominant projects of legal philosophy, specifically through legal positivism, from the top down, from what is going on in officialdom downwards as opposed to subjectivity upwards. So I'm hoping that those are the sorts of questions that are going to get clearer and clearer with subsequent iterations of this draft. But really a good, decent nub statement of what I'm trying to get at is on page 1 of the draft, where I say that the argument I'm trying to elaborate is that both Arendt and Fuller are proponents of a theory of law that hinges upon the institutional conditions through which a subject experiences her relationship with political authority, and the way that these conditions sustain her status as a person. Arendt and Fuller, I want to argue, not only ultimately share this view of law and were motivated to recommend it to legal and political theorists for essentially similar reasons, but read together make significant inroads into showing us what its normative commitments and institutional features must be. In doing so, they offer us the building blocks of a bottom-up jurisprudence that stands to challenge source-based accounts of law that otherwise dominate legal theory. Fuller and Arendt, I'm wanting to argue, are both fundamentally interested in the subject's relation to authority and what law has to do with mediating this and how. And they both, or so I want to say, arrive at the view that this how has everything to do with a distinctive institutional frame that law convenes at the moment of its administration. And by that I mean at the moment when law actually touches the lived experience of its subjects. I'm wanting to suggest, and I'm on my way to working out why I'm wanting to suggest it, that these ideas are not ideas we've necessarily got completely covered yet in legal theory. They're not yet all worked out. And what I mean here is that although there's a lot in common with what we might say theoretical conversations about the rule of law, that frame I think is not quite adequate to the particular insights that I see Fuller and Arendt pushing at. But I'll come back to that point when I've explored a little bit more with you what I have in mind with the particular passages I want to focus on. So first, to the fuller part of this story, just to give you a bit more background on the Forms Liberate project. Fuller has always appealed to me because I think I identify with some of his adventures and misadventures. And generally, as just a personality observation, I'm pretty much always on the side of the person who's being misunderstood. And that means I have a history of getting myself into all sorts of strife, usually for reasons that have got nothing whatsoever to do with me, just because I can't tolerate witnessing people miscommunicate or misunderstand each other, especially when the moves that are causing this misunderstanding are really quite obvious, to me at least. Sometimes they're deliberately deployed, sometimes they're not, but nonetheless, misunderstandings really bother me, and Fuller was misunderstood, and it really bothered him. And I know that it really bothered him because I spent quite a lot of time dealing with his archival materials at Harvard, and it was distress, essentially, that with which he met the reception of his work by H.L.A. Hart and others. He just didn't know how he could put forward a particular project and have it understood and portrayed back to him in such different terms than those he intended. So those archival materials are really quite illuminating. But I'm also been interested in Fuller because he's an odd fit within legal philosophy. He was very creative, he was very broad, esoteric even in the kinds of resources he brought to bear on illuminating given problems and questions of law. They range from everything from conventional philosophy to examples from architecture or economics or even psychoanalysis. He thought we would take or should take our cues for our theoretical questions and for the answers to them from practice, from what, to quote him, the prosaic facts of human life seem consistently to indicate to us. He could not tolerate binaries and oppositions and polarizations that led to unfruitful oppositions as opposed to subtle differentiations. He found that to be wasteful, and he found that generally life doesn't fit the binaries that philosophy tries to push it into. And at the broadest level, which I think is deeply relevant to how his thought was received, he was extremely awkward with the frame, and by here I mean the law and morality debate, in which he found himself needing to explain his intuitions when he chose willingly, so he asked for it, to answer H.L.A. Hart's famous representation of positivism in 1958, a representation that at least initially took place through a thoroughgoing, multifaceted defence of the positivist separability thesis. That frame of debate was never an easy one for Fuller. Just as he consistently resisted the label of natural law or kept saying, caveat, caveat, I would qualify what you mean by that, he also resisted the terminology of morality, and this is very clear in his private papers, his archival notes, but he also knew that if he just said, look, forget the terminology of morality and let's call what I'm getting at something else, trusteeship or ethos or something else, that the conversation would be over. There was one conversation at the time the legal philosophers wanted to have, and it was about the connections between law and morality. So you were either in the frame or you were not. But it didn't necessarily do him favours. So the Fuller that I see, apart from struggling his way through that frame, spent his career giving sustained attention to questions that were otherwise largely neglected by legal philosophers during his time. And uniting these questions, as I at least read him, and this is across his debates with Hart, as well as his more esoteric or sociological writings, is a foundational query. And it goes something like this. What work is the form of law doing, not just in the instrumental sense relevant to the ends being pursued through it, but in the non-instrumental sense of shaping the lives, roles, expectations and agencies of those who participate within it? Closely following this question about what's form doing and how does it affect, effect, shape human behaviour and so forth, is one about how we theorise this particular query and what's at stake in the choices methodologically and substantively we take or we make when we theorise those questions. What I tried to do in Forms Liberate was give both of those questions a central place. And as a result, the book's as much about Fuller's jurisprudence as it is about the context of the debate in which that jurisprudence found expression. So it was a clean-up job as much as a ground-clearing job, in that I sought to clarify what he meant in those law and morality debates from a larger witnessing of his canon, at the same time as I wanted to kind of put those debates to the side and make way for the new conversations that I thought he was always trying to have about the distinctiveness of law's form and the implications of that distinctiveness for law's agents, and lawgiver and subject alike there. Some of the reactions to the book have been interesting because there's a sense held by some that I want to have my cake and eat it. I want to tell you what he meant as a contributor to those law and morality debates, the same way as saying I don't think they're the right debates to have. But that, to my mind, was the only approach available if I was actually to be true to the project that Fuller undertook, which included a genuine effort to join those law and morality debates if push them into new directions, and also simply to illuminate a contribution that's been notoriously difficult to pigeonhole or to measure so far. And I don't think sticking with the conventional law and morality frame is necessarily going to help us to characterise that contribution. So within this, my main emphasis has been on Fuller's interest in what it means to be a legal subject. So that brings us directly into the territory of this draft. This is partly a reactive move in the sense that legal philosophy generally has not as much to say on the question of what it means to be a legal subject, or certainly legal positivism doesn't have much to say on that question because its interest is in what's going on at the source of law, in what officials do to give us this thing we call legality. They look to the top, and they're entitled to do so, of course, but what's always bothered me is how in the treatment of Fuller, positivists have sought to portray him often as essentially doing the same thing. And this has been the direct result of how Hart replied to Fuller on Fuller's claims about the morality of law, the so-called morality of those 8 principles of lawgiving. What Hart said was that there was nothing moral about those principles, but they're rather like the principles of a poisoner's craft, aiding the efficacy through which the enterprise of poisoning is pursued. So I just want to emphasise the direction of the gaze here. It's to the poisoner or to the lawgiver. There's no one else really in sight in that answer. And so if we map Fuller onto that positive answer, what we learn is that he gave us some important principles of efficacy, call them, if you will, the principles of the rule of law, that aid the technique of lawgiving. That's what we're to take from Fuller in the conventional positivist interpretation. And yet, of course, Fuller said much more than this, and I think what's most relevant to what I'm trying to get across is that he was looking both at the lawgiver and the subject at the same time. He was, of course, interested in the lawgiver's desire for efficacy, but he was also looking at the frame through which lawgiving takes place and what that does for and means to the person on the bottom, the legal subject. And indeed, one of the most interesting archival notes I found in the Harvard collection was Fuller's notes for his final reply to critics, which were really what a lot of the book was based on, where he's trying to get at the best way to respond to this efficacy charge, or this frame, that what he's saying about the rule of law or the principles of the morality of law is reducible to the value of what makes law effective for a lawgiver. And in those notes, he says a lot about how what positivism neglects is, quote, the other fellow, the person on the bottom, the person on the other side. Sadly, not as much of that subject orientation makes its way into the published works, but it's very, very clear in his working out of ideas. So what I've been arguing for a while now is that if you were to understand Fuller's project, and I mean in lots of its different dimensions, it's interested in practical conditions, its orientation to the relationships that constitute law in action, its interest in what distinguishes law from other modes of ordering, and its interest foundationally in that Hart-Fuller essay of why a subject would display fidelity to law in the first place, we have to look more closely in what he's got to say about the legal subject and the distinctive conditions that law provides for her, which is why I've repeatedly emphasised a passage that I'm just going to put up here that others have also more recently emphasised in their reading of Fuller. This is in chapter 4 of the Morality of Law, which was a place where for a while I don't think many people look. The famous part of Morality of Law is your tale of Rex the lawgiver. That's all in chapter 2. This is in chapter 4 when he's defending various ways as why he is talking about morality and why his frame can be pushed into that. And it's part of a longer conversation about those points. But it struck me very early in my research to be saying something that we need to make more of, not just interpreting him, but in legal theory that's interested in conditions of subjectivity. Just to read it out, I've repeatedly observed that legal morality can be said to be neutral over a wide range of ethical issues. And by that, Fuller never said that if you followed the rule of law followed his principles of the internal morality of law, you get morally just ends. He never said that. The debate was never about that. Hart narrows it to those understandings initially, but subsequent positivists, Raz in particular, clearly understand that that was not the question. The question was rather more about the conditions, the associations between concepts of law and concepts of the rule of law. But what Fuller goes on to say here is that legal morality, these conditions that he associates with his internal morality of law, can't be neutral in their view of man himself. To embark on the enterprise of subjecting human conduct to the governance of rules involves of necessity a commitment to the view that man is or can become a responsible agent, capable of understanding and following rules and answerable for his defaults. It's a bit hyperbolic, but every departure from the principles of law's inner morality is an affront to man's dignity as a responsible agent. To judge his actions by unpublished or retrospective laws, or to order him to do an act that is impossible, is to convey to him your indifference to his powers of self-determination. Conversely, when the view is accepted that man's incapable of responsible action, legal morality loses its reason for being. To judge his actions by unpublished or retrospective laws is no longer an affront, for there is nothing left to affront. Even the verb to judge becomes incongruous in this context. We no longer judge a man, we act upon him. There's a lot that can be said about this passage, and I've said different things about it at different points, but at the moment what I'm interested in is two main things. Firstly, what Fuller says to us in this passage about what happens when a putative lawgiver, and I say putative because what he's getting at here is that something collapses in the presence of law when these conditions of legal subjectivity are debased. So he's saying, what is it that happens when the putative lawgiver interacts with the subject through the medium of formally debased law? Here he speaks about there's not merely an affront to the subject's status as an agent, but there's something rather more drastic that's happened in the sense that we actually risk rendering the subject into something that's been merely acted upon and which Fuller suggests is unintelligible to law. So law is out of the picture once we are in an acting upon mode towards a subject. Legal morality loses its reason for being if we don't understand the subject as a centre of initiative. The other point I want to make here is that I'm interested, and I believe Fuller was interested, much less in whatever the prior conception of agency is of the person that comes to law. I don't think that there's an idea that he personally explores of the agent as somebody who is independent from the specific structures of law he is interested in uncovering. What I'm saying here is that he is concerned with the status of personhood vis-a-vis authority that law distinctively generates. What is it that arises because of law and which he's suggesting in this passage is especially apparent in its absence? What I do in the paper is go on to explain that these ideas are conveyed particularly forcefully in sites within Fuller's canon that he wrote around the time of his final reply to critics, when he is struggling with how to answer Hart and others on this notion that everything he said just boils down to efficaciousness and so forth. In those notes and in various sites of his writings outside of the Hart-Fuller debate, he pays much more attention to bringing the subject in the picture and how that qualifies this very top-down viewpoint that he has received from positivism. And among the points he makes is he distinguishes positivism, he distinguishes law in his sense from what he thinks law in positivism's sense boils down to, which is a rather crude distinction that he makes between law and managerial direction, which descriptively he thinks is more what positivists get at. But among the principles that amount or account for that difference is Fuller's interest in the idea of congruence between official action and declared rule, something I want to make more of than I do in this paper. What he gets at is that this principle of congruence, the fact that the lawgiver will actually do what they said they would do, speaks to something crucial about the equality of subjects and the intelligibility of law to them at the point when the normative demands that a political authority seeks to impose through law actually touch the circumstances of the subject. This is where the action takes place for the subject, in that administrative moment. So it's a deeper message there in the congruence idea about the relationships and relational expectations that Fuller thinks are constitutive to law, written to its form and distinguish it from other modes. And the experience of the subject is crucial here. And that's something that I'm trying to tease out in Fuller. How a subject experiences law is not a matter of mere sociological interest. It is also that, but that's not all there is to it. There's something constitutive there about that experience, which then of course opens up lots of questions for legal theory, that if we were to entertain that idea, what does it mean for us methodologically and so forth? How do we bring experience in to theory? So what I take from Fuller, and of course this is just a little snapshot of what is otherwise elaborated in my book over a much broader territory, is that this figure of the legal subject does not exist separately from the features and qualities of the institutional arrangement that brings her into being. It's not an abstract idea, but rather very closely linked to the particular way that law registers her status as an agent. Fuller will not let us think about law without taking that idea into account. Which brings me to the Arendt part of this story. Because if you'd spent a long time thinking about these ideas, you might have a sense of why I had a certain intuitive recognition when I encountered certain ideas of Arendt's that I bring into the picture in this paper. I might be doing something novel with those Arendtian ideas in that, insofar that I look at her notion of juridical person, I can find so far, and if anyone has any suggestions, please tell me, but I can't find any treatment of this idea anywhere. There has not been thought about what Arendt is getting at when she talks about this figure of the juridical person and the context in which she explores that. But that's where the novelty ends insofar that thinking about Arendt as a legal thinker is, I have a zeitgeist on my side here. There's quite a lot of this going on at the moment. And there was, in I think 2012, a book titled Hannah Arendt and the Law, with a collection of about 12 essays where different thinkers, mainly from the UK, looked at what it is in her legal theory that, what it is in her political theory that might tell us something about her legal theory. Those who are interested in her in this sense are especially those who are interested in rights, and within that group, particularly those influenced by Kant, but there's also constitutional and public law interests in Hannah Arendt because they are interested in her thinking on the connections between law and politics, or law and political action in particular. To that end, there's been a lot of focus on two ideas that Arendt visited, namely the Roman and Greek ancient concepts of law that she thinks preceded and therefore might be reclaimed in the aftermath of our modern, more command-based conception of law. Here I refer to the idea of nomos, which is law as a boundary within which political action takes place, so very close to constitutional thinking, but also law as lex, meaning law as arising from the relationship between entities like in contract, so something interactive and relational. She doesn't settle a view on, she doesn't want to say, I'm going to opt into either of these views of law, because that's not really what she's interested in. She's interested in why we have lost an interest in what she calls political freedom, or freedom through action in concert with others. And all I need to say to contextualise that is that Arendt is acutely aware of how ideas travel in packs, meaning she is interested in the loss of a particular idea of freedom, of the person as capable of new beginnings, of the person as capable of action, of the person as capable, as we see in revolution, of acting in concert with others to produce freedom. What happened to those ideas is her question, and she's quite convinced that it has a lot to do with the movement in the modern tradition towards negative conceptions of freedom. Aligning, because of the ideas driving packs scenario, with that prevalence of negative freedom is a command conception of law. You are free in the space where the commands are not touching you, and it's a very top-down orientation towards law that in that top-down orientation and combined with a negative freedom idea has very little to say about the human possibilities that lie underneath those commands. So she wasn't setting out to choose a new legal theory, she just wanted to know why we'd lost versions of legal theory that I would say seem more capacious in what they ask of the persons at the bottom, or not at the bottom, the persons that are involved in legal relationships, because of her interest in reclaiming notions of political freedom away from notions of negative freedom. So that's where most people have been focusing, on the nomos and lex, and I actually think I need to make more of those ideas, because when I'm heading at the end of this paper, and don't go far enough, into ideas about authority, I actually think that we need to link those ideas of Arendt's up with the ones that I do focus on. But for now, I'm just going to concentrate on what these ideas about personhood are that I see in her thinking, specifically in her writings in the origins of totalitarianism. I'm going to just refer to these passages in reverse order that I have in the draft. This is the passage from Arendt's very famous discussion of the perplexities I should say, of the rights of man, which is her famous discussion on citizenship as the right to have rights, which she extrapolates from an analysis of the implications of what it was like to be a stateless person in the interwar period. What happened to you in terms of being put in internment camps and otherwise being subject to non-judicial oversight and essentially straight executive power when you couldn't claim a nation-state to protect you. So we understand this passage, it's very famous, the passage is about the right to have rights, as a citizenship discussion. And I don't want to detract from that because it's very illuminating what she wants to get at about the implications of statelessness in that historical period or perhaps generally. But what I'm suggesting in my paper is that this analysis, but particularly this passage within it, can equally or even above all be read as very suggestive for legal theory. And I think it's very suggestive for legal theory because it seems to go to something about the implications for personhood of what I might call institutional statuslessness, about having no place within the institutions through which authority is mediated. I've been obsessed with this passage for the last few years and waiting for a chance to write about it because it intrigues me as an insight. This notion that the way that you can tell that you're outside the pale of law is if committing a crime would somehow benefit you, would somehow bring you to a better position than you're currently in. As she goes on, if a small burglary is likely to improve his legal position, at least temporarily, one may be sure that he's been deprived of human rights. She's very loose in which language she's using, rights, citizenship and others. For then a criminal offence becomes the best opportunity to regain some kind of human equality, even if it has to be recognised as an exception to the norm. The one important fact is this exception is provided for by law. As a criminal, even a stateless person will not be treated worse than another criminal, that is, he will be treated like everybody else. Only as an offender against the law can he gain protection from it. As long as his trial and his sentence last, he will be safe from that arbitrary police rule against which there are no lawyers and no appeals. The same man who was in jail yesterday because of his mere presence in the world, who had no rights whatsoever and lived under the threat of deportation, who was dispatched without sentence and without trial to some kind of internment because he tried to work and make a living, may become almost a fully fledged citizen because of a little theft. Even if he's penniless, he can now get a lawyer, we don't know about that these days, but complain about his jailers and he'll be listened to respectfully. He's no longer the scum of the earth, but important enough to be informed of all the details of the law under which he'll be tried. He has become a respectable person. In the paper, I emphasise this idea of the respectable person. It intrigues me. It intrigues me because it's clearly a status, and like all statuses, I assume that's the plural, they are relational. They are something that is a product of the way we envisage each other. So the respectable person is a person envisaged by others. But the crucial interest for my purposes lies in the fact that this status is exclusively institutionally driven. The surrounding institutional structure and the ethos that its processes generate for those who participate in them in the criminal justice system she's referring to here constitute a way of communicating with the criminal that's status creating, and it's status creating in a distinctively positive sense, in that it transforms him, she says, from a mere human, or worse, the scum of the earth, into someone important enough to be informed of all the details of the law under which he will be tried. Now this all resonates strongly with what Arendt goes on to say later in the same book in a different discussion where she introduces the notion of juridical person, hence why I've made the connection between the two, which is very obvious when you look at them side by side. In that later discussion where she's talking about the juridical person, this arises in her analysis of the modus operandi of totalitarianism and its domination. What she suggests that for totalitarianism to achieve its ends, to do its domination that it is constitutively designed to do, it must effect three kinds of annihilation of the person. The first is the killing of the juridical person, the second is the murder of the moral person, and the third is the destruction of individuality. My question then is, what is it about this juridical person? Who is she? What is it that is so resistant to totalitarianism? And when Arendt explains that to us, the example of the criminal is again crucial. So she has several things to say about the distinctive status of the criminal. She says things like the following: it's harder to kill the juridical person in man who is guilty of some crime than in a totally innocent person. So we have an understanding that, of course, the juridical links the person to some kind of legal, and that that legal frame makes this first stage of annihilation, first stage of what's necessary towards domination, to be difficult. But what is it that is in the juridical that is so interesting to her? She suggests some of these things. Only criminals have been sent to the camp in connection with some definite activity. So we know that the criminal is an actor. The criminal is not just somebody who thought viewpoints or held beliefs. The criminal acted as an agent in the world in some way, hence the criminality that attached. But then she also says the criminal knows why they are in a concentration camp and therefore has kept a remnant of their juridical person. This analysis also includes her, when I say the distinctive status of the criminal, she goes to some lengths to explain why the criminal should not have been in the concentration camp. Well, the presence of the criminal was an awkward one within the concentration camp system because they didn't fit the modus operandi of the concentration camp itself. There was something about the desire to make everyone into a non-actor that the criminal, by being recognised as an actor, stood against. But what we've got here at the minimum is some ideas that I think help us to flesh out what she's getting at about this corresponding idea of the juridical and thus the juridical person. We've got action, so recognition of people as actors and being maintained with the status of an actor. That person has knowledge of why they've encountered authority, why the experience they're having institutionally they're having, and thus there's an important measure of intelligibility in that knowledge. But we also have another important idea, and that is the notion of stability, or specifically stability of expectation in one's encounters with authority that the criminal has. This is what came through very clearly in that first passage, but it's also, I think, very interestingly, something that comes through when Arendt speaks of why the totalitarian version of legality can't have its own juridical person. In the paper I do a discussion I'm not very happy with, but what I'm trying to say in that discussion is that she speaks of totalitarian legality, but I think she gives no particular substance to what she means by legality in that discussion. She simply means that whatever, and I call it a positivistic kind of description, in that whatever officialdom says is legal or the law, is legal or the law. So totalitarianism has its own version of legality, which she explains to be the law of movement, the notion that there is never any stability, there is never any consistency. Law is bound up with a view of nature, man's realisation, man's destiny within that, and so forth. So the legality of totalitarianism, or its in totalitarian guise, is the distinct opposite of the kind of legality, or we would say the juridical, that she sees the criminal as participating within, and strikingly and importantly, that she thinks has to be broken down for totalitarian and presumably its legality to take root. They're very, very different. And that comes through quite clearly when she says that you can't have a juridical person in totalitarian legality. It's a very different idea. And again, she might be overstating things, but she suggests that even the most tyrannical restriction of what's otherwise arbitrary persecution, such as restricting groups by certain religious, political or other grounds, renders the camp superfluous because in any stability at all, even in this context, cannot fail to produce a new juridical person in man that eludes totalitarian domination. It's an extreme statement, but I am interested in what its animating idea is. This connection between the juridical, which I think she reads as a very normative notion, a realm that makes very strong normative demands on institutional actors vis-a-vis the treatment of subjects to law, that she doesn't align with any idea of legality in the totalitarian sense. So, before I move on, therefore, to a few leads that I open up in this paper that I need to think more about, I just want to make a couple of comments on what I'm taking from Arendt here. The juridical person I see as not just crucial to but constitutive to this very idea, this normative, rich normative space that she calls the juridical. And we need the juridical person because it's the nature of the institutional response to the person that constitutes that juridical realm. It's a particular way of interacting with and communicating with a person by authority. And it is very much, as she put in that first passage, to do with the particular structures and methods of that communication, how they are status creating and how the juridical is inseparable from them. So we've got an idea here that hinges on how the experience of being a legal subject gets constituted by the commitments of law's institutional complex. There's no meaningful conception of a juridical person, she tells us, just like Fuller tells us there's no meaningful conception of a legal subject, until and unless one's status as an agent is rendered tangible through that legal institutional frame and how it interacts through notions of recognition of action, notions of knowledge and intelligibility, and notions of stability. So 3 points, if I may. How am I doing for time? 5 minutes? I hope what I'm not doing here is just identifying similarities for similarity's sake, because that kind of project rightly invites the so what question, and I'm hoping I'm doing more here than deserves that question, although it's still very much in progress. What I do think I am doing here is making a contribution to legal theory that draws upon Arendt, because of this discussion of the juridical person, and particularly what to some Arendtians may be a surprising claim that there's a normative idea of law running through that juridical notion that she develops. That is a contribution on the Arendtian side, and I think there's also a contribution from Arendt to Fuller to be made in how much more explicitly she's interested in these institutional conditions of law's administration and how they are distinctly status creating, and that she's just more politically concerned than Fuller is. But, and I'll speak more in questions if we like on why I think that to develop these ideas we have to move out of the moral frame and to a more political one, and I'll come back to that because I think what's a more important point to make, or two more important points to make in closing, are my intuitions, concern my intuitions about the resonance of these ideas with rule of law thinking, and particularly with rule of law thinking as it links to questions of authority. I said before that I want to quietly, or maybe not so quietly, resist saying that everything I'm teasing out of Fuller and Arendt here collapses easily into theoretical discussions of the rule of law. And the reason I want to resist that is because the rule of law theory is itself highly contested space. And very arguably, the strongest or the most dominant theory of the rule of law that's circulating currently in legal thinking would be that which supports the neoliberal economic agenda and sees the rule of law as securing interests in private property. Now, that's among the rule of law conceptions that circulate theoretically at this point, and there's not a whole lot of concern in that for conditions of personhood, the relationship between institutional structures and participation, and those conditions of personhood that I think come through so strongly in Fuller Arendt. So I think there's something theoretically novel going on there that might be lost in translation if we immediately make this a rule of law tale, but perhaps this is just my usual visceral reaction to putting labels on ideas before we've worked out what the ideas are getting at in their own right. I may well land back in the rule of law camp quite squarely. But I'm interested in discussing, and more for your thoughts than mine, I suspect, the possibilities that my inquiry opens up to consider not just the conditions through which law authority becomes possible, but also the connection between authority and these conditions of the rule of law, these institutional subject interactive conditions. My sense is that to get at this connection, we have to reframe that inquiry as less about how much does authority rely on the rule of law, and I mean legal authority in particular here, than in the terms of authority, legal personhood, and law's institutional frame. So again, pulling out of the rule of law discussion something distinctive about what is law's institutional frame and what are its implications for legal personhood, and how does an idea of authority relate to those connections. I make some comments in this vein in the analysis section of the paper when I contemplate Fuller's discussion of fidelity to law, which always was met with some confusion by those who are reading Fuller through the heart frame of the defence of positivism. Why is he suddenly talking about what is it that generates a subject's fidelity to law? What I get at in that analysis, or try to get at in that analysis, is that what Fuller is saying about fidelity to law is that you can, the question is normatively whether he's saying we should, but that you have every right to withdraw your sense of obligation to law, your fidelity to it, when the authority through which it's expressed breaks down in its reciprocity to you. So when a lawgiver does not honour his side of the bargain, you can justifiably withdraw your fidelity to law because that fidelity is generated by the back and forth between you. That's the basic idea that he gets at. We've wrapped that up in discussions about law morality. They're much more interesting, I think, to be discussed in terms of law's form and its relationship to personhood and its relationship to generating authority. Because what's going on there is an idea that law's authority over us is not just relational, which is something that I'm sure many people would agree with, but it has to be tested through the subject's experience of laws, structures and commitments, of the experience of the structures and commitments of law's institutional complex. So what does our thinking on authority look like when we take those connections more seriously? So I think I'll leave it there, given the time, and I just want to repeat that I'm very grateful for the opportunity to present this early draft of the paper and work out where I think its centres of gravity ought to lie in the next iterations. But I'll hand it over to you. Thank you.